We are talking about how to avoid costly trademark mistakes, how to save clients time and money when it comes to trademarks. And for those of you that might be new or don't know too much about us, um, let me get to, I gotta go move slide. That would help. Uh, our law firm is Gerben Perrott. You're host of the CLE with myself, Josh Gerben, and my law partner, Eric Perrott.
Hey,
Uh,
everybody.
we we are we're we are celebrating our 16th year, actually, just this past month, as a firm. I opened the doors in 2008, for better or worse during the Great Recession. Managed to survive, and now here we are today. We currently have 8 lawyers. We're located in Pennsylvania, Washington, D.C., Virginia, Vermont, and Nashville. Our firm, we just do trademark work essentially. So when you look at our numbers, it's rare that somebody matches the amount of work we've done over the last 16 years. We've successfully registered over 8,000 trademarks for clients, not only here in the United States, but all around the world. We manage global portfolios for clients. We've settled hundreds and hundreds of trademark disputes without actually having to file a lawsuit, which is part of the topic today, where we save clients a lot of money. We've also overcome a lot of refusals that we've gotten from the USPTO over the years. And we've done a lot of work with what's called the Trademark Trial and Appeal Board, which is the administrative court, if you will, within the USPTO, where some trademark disputes are decided. So we've done a lot of that work. Our firm does work with clients from all over the US, just the nature of trademark law, and also work with clients from all over the world that need to file trademarks in the US. So that's the fun part about trademark practice, is you get to work with people from literally everywhere, and you get to learn a lot about their business and about various things that happen around the world. So as far as the CLE goes today, just wanted to give you a quick outline of what we're going to be covering. First, we're going to talk about how proper trademark clearance searches work to avoid problems in the future, which are always the more costly of things, if versus a good search. Why filing trademark applications early can really matter and save people money. How to avoid battles with squatters overseas, which is becoming a bigger issue these days. How proactive monitoring and enforcement can actually keep your litigation costs down. How to identify competent trademark counsel if you're not hiring us, and also how to avoid common litigation pitfalls. So these are all the things we're going to cover in the next hour. So I always start these CLEs with just a quick reminder about what a trademark is for those of you that might not dabble in the area too much. Typically, a trademark is defined as a source identifier, something that you would see on a product or a service and be like, oh, I know what company is behind that now. So the different types of trademarks could be everything from a business name of a particular product or service, things like slogans and logos, even sounds. Think of the Netflix ta-dum when you turn on Netflix tonight. That is a registered trademark. So anything that really identifies a company for a consumer can be a trademark. Nike is one of our favorite examples because they fit the mold so well on a number of things, but you have the name Nike. You have different product names. Nike Shocks is one of them. The slogan, which everybody knows, just do it. You even have the Nike logo, and then even you can register designs that appear on the shoes that would, basically what was called trade dress. And so there's things like packaging design or designs that appear on shoes that can even be registered as trademarks. And so there's a lot of different things that companies can do to protect themselves with all the unique IP that they create around a brand. And that's essentially what Eric and I spend every day doing. So to get us started, I'm going to talk about sort of the most basic thing when it comes to trademarks, and that is completing a trademark search once a trademark has been identified as something that a client would like to adopt and use for their company, whether it's the name of a new product, whether it's the name of the company itself, new service, you name it. We have a new trademark, and the first thing we should always do is a proper trademark clearance search. And I'm going to keep using the word proper because in today's world, there is a plethora of information out there and potentially resources, if you will, that would let you conduct a trademark search online. This ranges from everything that you might go on a website that claims you can just do a trademark search on their website. It's not a government entity, it's a private website. There's also uspto.gov where you can go on and do a trademark search there. And we're going to get to sort of reasons why these things might not be great ideas. But if you're going to do a proper trademark search, there are really three things you have to consider. One is the Federal Trademark Register. That's what everybody assumes a trademark search is that you're searching for trademarks that already have been filed or existed. And that's certainly part of it. The other thing that you need to do is search all 50 state government trademark databases. Trademarks can still be registered on a state-by-state basis. So for example, this is very common in the marijuana industry because you cannot register the brand of a marijuana at the federal level. But in states like California and Colorado and a few others, you could certainly get a state-based trademark registration. So sometimes if you're not looking and doing these searches of the state databases, there might be something in there that would prevent a client from using a trademark in particular states or having an issue with an infringement claim. The last thing you need to check is what we call common law. So this is the idea that if a company were to launch a product or service and just simply be using the name or just using their company name and never file for a trademark, they actually do acquire rights in that trademark under US law, under various federal and state laws. So we need to be really careful about somebody that might be building a business and have forgotten about the trademark registration process, but has rights, because those rights can then be used to come back and attack a registration that you might get for a client, or worse yet, sue the client for infringement. So we'll go over what a common law search is, but basically you're looking for any use in the marketplace that might be out there that could create trademark rights. And that's a very sometimes difficult thing to identify, but something that you should at least try to identify for a client. So the other thing to think about with a trademark search, and this is the most common issue, is that you're not just searching for the exact mark. You have to search for variations, things that could still be considered problematic. So common things that are overlooked would be items like phonetic equivalents, such as Coke. Like if your client came to you with Coca-Cola and it was Koka, Kola, some people might say, oh, I'm getting around the Coca-Cola trademark by spelling it this way. No, it's just not how it works. Anything that's phonetically identical could certainly be a problem. There's also something called foreign language equivalents. If your trademark has been registered for the foreign language equivalent of that mark, that could certainly be an issue. And there's also just commercial impression similarities. I'll give an example here of Here Comes the Sun versus Here Is the Sun. Those are very similar trademarks and would likely conflict, and one would be refused because the other might have a claim for infringement. So a trademark search has to consider, depending on the mark, all these different types of things that would go into it, right? So it's not just simply, oh, I'm going to look at my trademark, I'm going to type it into a database and see what comes up, and that's it, because that database might not be considering all these alternatives. The software is just not smart enough. So you have to think about all those different things that go into the search.
Yeah, Josh, I like telling clients that depending on which circuit you're in, it could be up to 11 different factors that go into this idea of likelihood of confusion. And I think some of them are more important than others. I think, what you said about the sight, sound, and meaning is an important one, but there's always then the last of the 11 factors, which is anything else that's relevant that could show confusion. So it is balancing all those different factors, and I think that it does take a lot of nuance in order to really hone in on the potential risks.
Yeah, certainly. And we'll get to this, and that's a great point, Eric, and we'll get to sort of how this saves a lot of money in the long run in a second. So I touched on this previously, but what is not a thorough search? Going to uspto.gov and running a search on their database by just typing in the trademark and leaving it there. There are ways to use the government's trademark search software, and there are people that are very experienced and know how to do it. But it also, the way it's set up right now, is extraordinarily misleading, because we have so many people that will go, clients that will go on it and say, oh, I've searched my name, there's nothing there, so I don't need you to run this search. And that's a tough one to explain around, because they're on the government website. They think they found sort of the holy grail of trademark searching, but just putting your trademark in there and seeing what comes up, that will never find everything you possibly need to look at for a trademark search. The same thing goes for anything that's on a third-party website. These are typically software tools that have been created and are helpful, but again, they're not smart enough to look for all the different things we were just talking about in as far as items that are not an exact match to the trademark itself. And finally, if you're only doing this federal search, even if you're doing the federal search properly, as we just kind of walked through, there's the state and common law element that if you're not looking at, you're not considering all the possible risks for the trademark. So what is our tip? One of the sort of tips here is that you would like to look for someone that's completed a lot of searches, and a lot of searches that have been federal, state, and common law searches, because they're going to be able to assess the risk for you from a pattern recognition standpoint, right? So if you and not to toot our own horn too much, but if we've been doing this for 16 years and we've done thousands of searches, when we look at a search today, we have a lot of pattern recognition about what the trademark office might accept or what might not. What are the issues that typically come up in litigation, all those things. And if you have someone that's relatively inexperienced looking at it, even if they have the right data, it could be really hard for them to analyze that data. So just something to consider there, even if you're getting the right type of search run. So if you are going to hire someone to do a search, what type of questions should you ask them to make sure it's getting done right? Here's just some tips, some things you can ask. What software are you using to run the search? Because there are the Westlaw or Lexis equivalents of trademark search software that you can use on a private basis to run a search. And we do that here at the firm. We use a couple of different software tools that'll kind of sort of trying to overlap and make sure we're not missing anything. So understanding what software the searcher is using is really helpful, because it gives you an idea of, are they spending money? Are they engaged in using a proprietary software that's going to be more powerful than what's publicly available, because those softwares do exist and are very helpful in doing an accurate search. Want to talk about how extensive is your search of similar but not identical marks. So because there are plenty of services out there that claim they're going to do like a knockout search, and that means something different to everybody. So you want to understand, how extensive is this search? Is it really just looking for real close matches, or is it broadening out from there? Do you rely on any AI driven search, or do you do it via hand? And I ask this question because AI is sort of the buzzword of the moment, but if you're just relying on an AI tool, it's like relying on ChatGPT to write your brief for you. You wouldn't do it, right? You might use it as an assistant. You might take it, might look at it. Hey, is there anything here that's helpful that I might be missing? But you're definitely not going to rely on that at this stage in the game. Look, 10 years from now, perhaps, but not right now. Will you be completing a 50 state and common law search, which is, we just talked about that. Many, from all the advertising we see other trademark firms and services do, most people do not offer those as well unless you're at a larger firm. How many searches has your firm done and analyzed? Again, just looking at the experience of the person analyzing the report, I think is important. And finally, if the search is going to be outsourced, some firms outsource the search. That's okay, but you need to know who they're outsourcing it to, and understand what that search, who that search provider is, and what their level of experience is. So we'll make these slides available, but if you ever want to hire someone to do a search, these are some pretty good questions to ask. Finally, before I get to the reason this all saves money, the biggest mistake we see, and this also leads to clients spending more money than they need to on trademarks, is before we've gone through this whole search process, which I've just outlined, and you've seen how much it just took me to explain it, let alone actually do a search. Clients will get really attached to a name. And if they are too attached to move off it based on what your advice is from the search, that's going to create a huge problem. Ultimately, I've been co-counsel some really good lawyers who are even sometimes a little blunter than I am, and they will literally tell their client on the call, hey, if you move forward with this, it's going to cost you a ton of money if you have a problem. Whereas you could just spend a weekend and come up with a different name. You're going to save yourself, potentially, it literally could be millions of dollars, right? And so making sure that a client understands that coming to you early with a trademark, and not once they've fallen in love with the name and have to have it, or they're, a year into operations, which, believe it or not, a lot of people come to us once they're already open and operating. But the earlier you can get it, the more flexibility there is, the better the outcome typically is for the client. So what does this all cost? Average cost with us to do a trademark search, and again, there's always things that can come up, but we typically charge around $800 to do the search and provide our analysis. If you're at a large law firm, this could be $2,000 or more. Searches are probably comparable. What I would say is that if somebody's pitching you a search and it's less than $500, chances are they're not doing everything I'm outlining here. And as long as you're aware that they're not doing those things and you're okay with that, that's one thing. But just be careful, because we have a lot of people that come to us and say, well, I could do a search for $49. Yeah, you could, but that's a heck of a lot different type of search than we're going to do. So it's really hard for a consumer to compare apples to apples on trademark searches, because there's so much out there online really. And when they're researching it, they see so many different things and so many different price points. They don't really know what they're buying. And so that's just a huge point of education, but something that we bring up. And of course, if you have a problem with a trademark that wasn't properly cleared, you're talking about you sometimes can't even value that, because you would have all the lost brand equity. All the advertising and marketing goes into a name that then has to change. You almost can't even come up with a number, right? And so, let alone the cost of just coming up with a new name and all the change that has to happen around, if the name has to be changed, whether it's signage and websites and all that kind of stuff. So the cost of running these searches, while a lot of people don't like the idea of spending $800 or a couple grand to get a no, it's actually the most valuable thing you could get, and really good money to be spending to avoid problems later on.
Yeah, and I'll so we have some questions coming in. Feel free to send them through the question and answer, and we can kind of work them in as we proceed through the presentation. But this is about avoiding costly mistakes. And one of the questions that we get from clients is, when should I file my trademark? And the answer to avoid these kind of mistakes is as early as possible. And when I say that, it means that when you have a set idea for a trademark, you know what you're going to use it on, you have kind of a game plan in place, then you can file a trademark application and utilize something called an intent to use application in order to maximize the benefits. And so to take a quick step back, one of the kind of cornerstones of the US trademark registration process is this idea of use in commerce. And in almost every case, the person who uses a trademark first is going to be the one who gets to utilize it in the marketplace for the goods and services that they've been using it. And there is an exception to that, and that is something called an intent to use application. And this allows someone to essentially reserve rights in a trademark before they actually begin using it by filing a application with the U.S. Patent and Trademark Office. It gets reviewed, it gets examined, and it will get all the way to the last stage of having to file the proof that you're using it. And you can get that in early as possible. Why that is important is because your priority date, meaning your date that you would have prior rights to others, would begin on the date you applied rather than the date you began using it. And the reason why this is important is I'm actually going to use a local example for DC, as there was or there still is a brewery called Atlas Brewery. They filed an intent to use trademark application when they decided to open the brewery. It was in Washington, D.C. And they filed this application. And then maybe about a month later, a Chicago brew pub called Atlas Brew Pub began using their trademark application. And after a very long, drawn-out process, the Atlas Brewery in Washington, D.C. was able to say, "Listen, we reserved rights in this ahead of time. You used it first, sure, but this is something that we reserved ahead of time, and you're going to have to change your name because we already have plans for this." And it was something that there was a lot of back and forth between the parties, but ultimately, without that, if Atlas Brewery, the DC brewery, was to just kind of have waited till they actually launched, the tables could have been turned completely, and the Chicago brew pub would have been able to say, well, I used it first, so at least in some circumstances you wouldn't be able to use your trademark, because the Chicago brew pub then also applied for a trademark application. And so it's that kind of thing that it can come down to days, and it's a situation that it's not likely that it'll ever come down to that kind of date, but that's why time is of the essence. And it's important to file as early as possible. And so the question of exactly when, so a trademark application takes about 12 to 15 months to go through the entire process. And then there is 3 years worth of extensions that can be filed every 6 months. And so usually the sweet spot that I consider is about a year to a year and a half before you plan to launch is a pretty good time to consider filing, because that gives you a budget-friendly amount of time and some buffer. So in case you don't get it done in that year and a half, you've got a little extra time, and that gives you the opportunity to take extensions if you need them, but ultimately you file that proof of use later. And that really can be the difference between one party being able to use it and one party not, when it comes down to who filed their intent to use trademark application before them. And so it can be a way that can save a ton of time and money to not have to worry about whether someone else will file something in the while you're waiting to kind of develop your trademark and get it launched. If someone else files something before you, then there could be a situation in which you're in a bad place very early on in the life cycle of your trademark. And so you want to get these filed as soon as you can.
All right. Next question, real quick. Is there any way to defeat a constructive use date if the actual use from the other party is not extensive?
That's a good question. So constructive use date is another word for priority. So if you have constructive use, it means that you may have a priority date that's earlier than your actual use date, because the way that the Patent and Trademark Office and trademark law considers an intent to use application is that it was as if you were using it the date you applied. You get rights that date back to that intent to use application date. And the answer is, it's going to be very lawyerly answer is, it depends. Use has to be in interstate commerce. And so if someone does file a trademark application and they file their proof of use based only on in-state commerce that has no effect on interstate kind of things that Congress can control, then that could be a way to cancel a trademark registration on the grounds that your constructive use date was not actually valid because your entire registration wasn't valid. Yeah, other than that, if there is just minimal use and it is across state borders for each of the items, there's not a lot of good ways to defeat that, but there could be a number of different strategies depending on the specific circumstances. And I think we actually skipped one that I found pretty interesting. And so just as it's a pro tip, so real quick, so when it comes to this idea of constructive use or priority, there are other ways to get a earlier than expected use date. And we are part of something called the Paris Convention. It allows you to file in one of 180 countries. And as long as you've got a trademark application in that country, then you can use that as your priority date in any other Paris Convention treaty signatory. And so what happens for a lot of brands, because what if you don't want to make your application public? Because that's something that's actually very real, that once you apply, and we'll talk later about things you should do when you apply, like make sure you grab the social media, make sure you grab the domain name, because it's public record. And so, what happens if you're a company that doesn't want that to be, or your client is a company that doesn't want that to be public record? It is more expensive, it is more advanced, but you can file in another country and then use that date 6 months later to file in the United States and use that date from 6 months ago. It's has a long history to it that dates back to basically using steamships to bring trademark applications back and forth, but it is a benefit, and it's a really kind of a pro tip to consider if you don't want, if you're ready to get trademark protection, but you're not ready for it to be public, consider using one of these things, sometimes called submarine filings or stealth filings, that help give you kind of an upper hand on the priority date. Yeah, and as far as kind of the cost of filing early, we talked about that situation with Atlas Brew Pub and Atlas Brewery. If that would have gone all the way down to federal court litigation where the parties were battling it out, easily could cost upward $200,000 or more. The damages, if they kept using it and were a huge success, both parties, there could be significant damages involved. Versus filing an application early gives a upper hand to a party that is just, in my opinion, worth it, and is much less expensive than having to deal with litigation later because of waiting for making a filing. So I always recommend to clients, if they're considering waiting, then really, really consider the risks that someone else could file something while you're waiting, and always kind of keep that in the back of your mind as you're developing a business plan.
Yeah, absolutely. And we hear every day from clients that, oh, they've got a lot of things going on, and maybe a couple $1,000s for the trademark isn't budgeted in. And it really, it'll never cease to surprise me, just because I run a business too, and I understand sort of what goes into it, that we don't have that budget set aside, just given the potential, for a problem and how much that problem could ultimately cost the company. So being proactive about these things, especially, even if I know there's general counsel on this call, a lot of times what we see in larger organizations is that the marketing people don't get things to legal until it's too late. And maybe they're about to run it in 2 days and they've got all the collateral done, and there's really not much we can do to change their minds on the trademark. Or from the search perspective, maybe we really should have gotten a filing made earlier. We had a client a couple of years ago that did follow our advice and filed early, and it was really important because they're sort of a larger company, and there's another larger company, and they both were running ads using basically the same tagline one spring. And so we felt really confident that we were not going to have a problem because of the trademark filing we had made, and the other side had not even made a filing. So it's one of those things where even internally, that sort of communication between marketing and legal, it sometimes is not super clear. And we, just in a larger organization, and the more that I think general counsel and in-house legal can talk to their marketing staff about getting them things early so that they can do these searches and can get these things filed to get that priority date in place, is really helpful. Most marketing people are more interested in sort of the how it looks and feels, and they hate legal, but can really save them a lot. So along the same lines of filing early, there's a question that typically comes up about outside the United States, because everything we've been talking about so far is inside the US. But a lot of companies in today's world, especially, do business outside the United States. And sometimes we'll even get requests from people that say they want to register a trademark worldwide. And I always say that's great, but I don't know many people that do worldwide, just because you're literally paying costs typically per country to file a trademark application, with an exception being the European Union, where you might be able to file one application to cover all the EU countries. So the question becomes, well, what do we do about foreign countries? Because one of the things we have seen is that if you do nothing, other people will file your trademark for you. In other words, you will have people that squat on your trademark overseas, and the cost of dealing with these squatters and getting them to basically cancel the registration if possible. There's some countries like China where you can't even get a registration canceled for a couple of years if it's, unless there's some real strong evidence of bad faith. And so you might have to pay somebody off. You might have to, just to buy the trademark back, essentially. And there's sometimes where you might have to not have the trademark and maybe not be able to enter a market. So, the idea that the priority date that Eric was just talking about applies in other countries as well. And so getting the trademark filed basically makes it impossible then for a squatter to do anything to you. And so it comes back to this idea of, normally there's a budget question of, well, how much money do we want to spend registering this trademark? Because again, every country is going to have an expense. But if you do get it registered and then you have sort of the freedom to operate and grow into those countries, there can be a lot of value there. So you have to sort of balance that internally with what's going on with a particular brand. It can also have added benefits, for example, of dealing with counterfeits. Like if you have a factory in China making a counterfeit, you can identify the factory. If you have the trademark registered in China, there's a lot you can do to shut it down. At least, in most cases. So how do we think about strategy around these foreign filings? I typically tell clients the first thing to do is come up with a list of countries that you want to register in. This would be obvious if you're planning to sell your products or services in those countries. That's a no-brainer. You absolutely should be registered there. If you're going to manufacture or distribute a product in those countries, you should also do it. The biggest mistake we see companies make is they will go find a local distributor for their product, sometimes a software product or sometimes a physical product, and that distributor will then go ahead and register the trademark for them. And then the distributor owns the mark. So when there's a falling out between the company and the distributor, now all of a sudden we got a problem, right? Because the distributor's like, well, I own your trademark and I'm not giving it back to you. And that happens. And so we want to be real careful that anytime you're doing business in a country, we are being very proactive about registering the trademark there. And these are the common places we do it. The other place you might think about it is if you are globally expanding, thinking about what countries are sort of possible in that expansion to get those filings made. And this is the biggest reason why. Normally, and again, these are all average costs, higher or lower, depending on the situation and country. It's about, I tell people it's about $1,500 a country. Now that's with our firm. You know, some firms are going to be a little bit more, some firms are going to be a little bit less, but typically it's about $1,500 a country. If I'm dealing with a squatter in any given country, the lowest bill we typically have is around $10,000 because we have to go hire a local attorney. We have to file cancellation actions, or we have to, you know, settle a case by buying the trademark back. There's all, you know, it's not normally an easy solution. And so if you're going to spend $1,500 versus 10 grand, and you're going to do that over 20 or 30 jurisdictions, you could see where you were saving a ton of money by just being proactive with the filings. Seems simple, but it can be actually a little hard to get an organization to allot that type of budget to filings. But it's something that should really be considered, especially on very important marks or marks you don't want to have to change in other countries. So that just kind of sort of adds on to Eric's points about filing early. It doesn't just apply to the US, it applies to things that you're doing overseas.
Yeah, and Josh, let me just double down on that. I was talking to a potential client who said that a squatter in China was squatting on like their main consumer good name, and it cost them over $100,000 to deal with. And it was, that's a rare one, but my eyes were very wide as she described all the stuff they had to go through to basically like work with Chinese authorities because of some bad faith that was happening. It was unreal.
Yeah, happens all the time for sure. Especially in China. I mean, it is a tough place to do business. Yeah. So the next one on our list here is it gets more into the enforcement and monitoring of trademarks, and why that doing that proactively can actually save money, because it really does do a good job of keeping you out of litigation. So if a trademark owner is not monitoring a marketplace, this is a fundamental rule, and allows a lot of other people to use a trademark or something similar, the rights over time become very narrow to sometimes even unenforceable. So it is the responsibility of a trademark owner to do enforcement and policing. I will tell you, some do a lot more than others, and everybody's definition of what you should do is going to be a little different. And this depends a lot on the trademark itself and how important it is to the company, but also you know, what type of industry you're in sometimes. It's just something that essentially needs to happen in order to maintain at least a decent amount of rights. So how do we monitor the marketplace? Well, there's a couple of things you can do. The easiest one is setting up a Google alert. This can get a little overwhelming to check every day or every week, but having Google alerts does alert you, especially if your mark is unique. It's not the word Apple. If it's the word Apple, you know, that's not going to help you much. But if it's a unique mark, the Google alerts can be really helpful. You could go and search social media, have someone on your team do that, have someone on your team search Google. Those are all good things that'll help you start to identify potential issues. For example, if you have a podcast, you would search, you know, Apple Podcasts or Spotify for any similar podcasts that, you know, names that might be out there. You can also monitor new filings that are getting made with the PTO. This is sort of one of our favorite things to do. Is we have a software tool that will alert us if there's a similar trademark filed to one of our clients, and that really lets us see what's getting filed. And in a second, I'm going to talk to why that can really save money, because, you know, if we're going to catch these things earlier, a lot of times we find that our enforcement job is much easier. So how do we enforce a trademark? First thing you have to do is you do have to evaluate any enforcement targets you identify pretty carefully, because there are times where even a client will bring us something and say, hey, I found an infringement, and we'll really realize that person was using the trademark before our client, or used it before our client filed an application. So we have a priority issue. We might not want to might not want to poke the bear. So we want to look at different factors. Don't just jump into enforcement. The first step is really identifying potential targets. The other is making sure from a legal perspective, you're not going to do something that's going to come back to be a problem. You also have to look at, you know, sometimes, again, is the infringer in the US or not? If they're not in the US, then do we have rights to even enforce this trademark in that particular country where the infringement's occurring? We have a lot of tools in the toolkit when it comes to enforcement. Typically, we start with a demand letter. That's pretty common. Everybody understands what that is. If that in some level of negotiation doesn't work, we can do, in certain cases, takedown notices. For example, on Amazon, if someone's selling a product that is creating a problem, we can go in there and ask Amazon to take it down if we have a registered mark. So another reason to get these marks registered. You do things like domain disputes if someone's squatting on your domain. When it comes to USPTO filings, we could do a letter of protest if we identify an application early enough to notify the examiner that's going to get that application. Hey, we think this is too close to ours. And it sometimes will influence the examiner's decision to actually issue a refusal. And that's a great tool, because a letter of protest might cost $1,500 a draft and file. But if you get a refusal, now you don't have to do an opposition. Because if the government approves the application and you have to oppose it, if that case goes the distance, it could be $100 grand. So the letter of protest, letting the government do your job for you from an enforcement perspective, can be really helpful. If the letter of protest isn't successful, or you catch something later, you can oppose or even try to cancel a registration that's been granted. And of course, there's the option of filing a lawsuit in federal court. So when you look at this list and you look at all the things you could do, what I always remind folks of is this, is that if I catch somebody really early on in their business and I say we have a problem, you are much, much more likely to get them to make a change than if they're a year in. Because if they're a year in and they have revenue, and especially if they can afford a defense, to put up a defense and try to draw you out, now all of a sudden you have a real expensive battle on your hands. So if we're talking about how to control cost, some people may say, well, I don't want to have to spend money on monitoring and then on these demand letters and all this other stuff. And I'm like, yes, but if you come to me with a problem that's been baked in for 2 or 3 years and I have to undo it, typically we're talking about the last thing here, which is filing a lawsuit in federal court, right? And if I file a lawsuit in federal court, the first thing we do is ask a client for somewhere of a retainer in the nature of $15,000 to $30,000, because we're going to go through that in the first month or two, no question. And then as the case would go on, you could easily end up, at least getting into a $50,000, number before you even get to discovery. And if the case goes through trial, you could be literally in the millions of dollars. So if we're identifying these targets and getting them to change things before they get too far along, you might spend $5,000 or $10,000 per enforcement target. And this is, again, a general, just to try to give you some numbers of what we see in our practice, but you might spend $5,000 or $10,000 and you stop the problem. Well, to some people, that's not that much money. To others, it might sound a little expensive. Again, if you're trying to stop these problems before they get too big that you can't even handle them, right? So we have clients that'll say, well, I couldn't even afford that if I wanted to, so maybe we can't do anything, right? And now we go back to what I said at the beginning of this section, which is that if you don't police your trademark, you can lose rights to it. So now a client is faced with a situation where they don't want to spend the litigation money, but somebody's using a trademark they really shouldn't, and that's now eroded rights around their mark, and they have a much less valuable mark. So if they would have started the enforcement process and done the monitoring and identified the targets and done the enforcement, they might have been able to stop the problem from occurring. Now, of course, it's not, nothing is perfect in this world. Nothing is as clean and easy as we want it to be. But in our experience, the vast, vast majority of enforcement cases we handle never even get close to litigation, because there's so much negotiation that can be done. And this is what we're going to talk about here in a minute, after the next section. There's so much that can be done from a creative solution standpoint to really off-ramp trademark disputes before they get too expensive. I could pause there for any questions if anything's come in. Sorry, I don't have that screen up.
I pulled a few from the chat here.
Sure.
Is it possible for someone to dilute their own trademark by using too many different marks on their product?
I think that's more of an advertising question than a legal one. From a legal perspective, yeah, there is one of the 11 factors is the strength of the trademark, and that's both intrinsically and extrinsically. And so if it is a made-up word or something like that, then it could be intrinsically strong. But if it is one of 50 different words or phrases on a package, I think that it would be harder to argue that any one of those would resonate as much with the consumers, but it'd be very fact-based. So I think it's possible, but in general, it is more of a, making sure that consumer recognition is high helps make a legally strong trademark as well.
So this next section's a little self-serving, I'm going to admit, but it's something I like to talk about because we see so much craziness in our world when it comes to trademark counsel, particularly opposing counsel in trademark cases. You get a lot of different types in the sense that you sometimes get folks that do trademark law as we do, which is that's all you do. And those attorneys tend to be very realistic about settlement and about how to handle a case. And then there's some counsel that don't practice trademark law all the time and come into a trademark case and kind of make it a lot more expensive because they don't know what they're doing essentially. So talk about the importance of hiring proper counsel. Trademark law is nuanced. There's no question about it. There's a reason that Eric and I can spend our entire day, our entire year, our entire career on it. And still we both admit we're learning things. I learn something new all the time. There's just so much that goes into the nuance of trademarks. And probably the most interesting way to explain it is this, is that there's really never two cases that line up and are the same. Every trademark case is a little different. The facts are always going to be different. The trademarks are always different. So you don't have a lot of, you try to rely on analogous case law, but there's normally not a case on point unless there's an issue of law and, that's very similar in a case to case basis. But most of the time the question is, are these trademarks too similar? And that is normally not been decided before. So there's a lot of nuance that goes into it. There is an attractiveness in the last decade of the idea of a business model for attorneys, because trademark law is one of these areas of law that you can go online and advertise and get clients from. And in 2008, I discovered this, and that's how I got my practice going. And I can tell you, when I started, there were not a lot of people hawking trademark services. And now there feels like I could throw a stone and hit 10. And so it's an attractive business model for attorneys. People, like it because they can charge a flat rate, they can file an application. And if they don't do a lot of the things that we're sort of talking about here in the call today, which is running these searches and spending all this time on things, the time required might be relatively low if you're not being very thorough. So it's an attractive business model, and you have to be careful because there's a lot of people that have moved into this space recently. And so, what we're seeing is that when we see people pop up and they're buying Google ads or they're, SEOing their website, and we look at and they're saying, hey, I'm a great trademark counsel. Well, go look at what they've done. They've maybe filed 30 or 40 applications, sometimes maybe a couple hundred, and gotten 20 of them registered. They might have 2 cases under their belt with the Trademark Trial and Appeal Board. So, you have to be real careful about who you're hiring and be careful of the marketing that's out there. If you're really looking for a trade,
I was going to say, be careful also. And if there's any personal injury lawyers on the call who are also trademark attorneys, I apologize. I am sure there are some good ones. 2 of the ones I've been up against have actually since been disbarred for representing their clients. And so fighting the urge to kind of go off in the different directions is also often hard for attorneys, but that has been my experience, is that if you are a trademark lawyer and personal injury lawyer, then if you can do both well, that's great. I have yet to meet one that has done both well, but it's always a chance. Sorry, go ahead, Josh.
No, I think that's an important side, and that's yeah, exactly, and that gets into being wary of firms that do a lot of things that tack on trademark law. Look, if you're with a large law firm, international firm, they're going to have a trademark department. That's not what I'm talking about. I'm talking about firms that are 15 people that do a bunch of different things plus trademarks. Normally, they don't have somebody that's just a really good trademark counsel. They just have people that know enough to think they're competent to do the work. As I mentioned, just a minute ago, taking a look at how much work somebody's actually done. PTO is very public. You can go on there and see. I see a lot of advertising where lawyers are calling themselves award-winning. I don't know what that means. I've been practicing for a really long time. Nobody has offered me an award yet. Maybe I'm just not good enough. I don't know, but I call BS when someone says they're award-winning, because I don't know what awards you've won. And then, of course, the low cost. Look, you're paying for what you get most of the time. I think there's always a balance with legal fees. Like, if you hire a firm that's like us, which we have 8 lawyers, we're a heck of a lot cheaper than a large firm. But I'd argue if you hiring us for a trademark matter, which is all we'll take you for, we're going to be just as experienced as that big firm in everything we do. If you hire someone that's offering a search, and again, if someone says, I'll do a search for $49, I just guarantee you they're not spending the time they need to. It's just not possible. So just be wary of super low cost stuff, as you would be in anything else. If you're going to go buy, anything at the store, and there's one that's 99 cents and there's one that's $10, there's probably a reason that they're a different price. And that's just something to be really cognizant of. Eric, do you want to take this one or should I finish it up?
Yeah,
This is
I mean,
all-
I think that one of the most important things that a trademark owner should know is when to enforce their trademark, but then also when not to enforce their trademark. I think having a thoughtful strategy that comes down to where is your line in the sand is unbelievably important to develop as early as possible to get as broad of trademark rights as possible, but not be a hard lined, we don't negotiate, you are my way or the highway kind of you trademark owner, because those do exist, and oftentimes they require enormous budgets to actually do that. They've got very strong trademark rights that are going to be easier to enforce, but it is also going to be very, very expensive and often on the outskirts of what should be possible. And so the idea of jumping right into litigation is always, I consider litigation to be a last resort. If we are in litigation, it is because things have gone wrong, or there's like a situation like counterfeits. I don't mess around with counterfeits. If I can't get that done quickly, that's something you've got to really take seriously and get immediately. But most of the time it is a discussion between business owners, and it is trying to find some kind of solution that both sides can deal with. And knowing where your rights start, where they stop, and where the kind of gray area is that you might be able to hold the line, I think is important. But there are millions of trademarks, and you're one of those million, or your clients can have one of those millions, and finding ways to coexist in the big marketplace is something I think that works a lot of the time. Sometimes it doesn't. You got to be ready to flip that switch into litigation mode if you have to, but there are meaningful ways to settle disputes through channels of trade restrictions, through kind of walling off certain areas so that you get it in these states. But I mean, that's also not very realistic with the kind of internet these days. But there's ways to potentially do it that both sides can live with, and that you won't you spend more than it would have taken you just to kind of develop a new trademark in order to kind of get what you need in order to protect the trademark. So I think that's important. And when litigation is necessary, if a lot of litigation shops are there to bill hours and they're not there to settle, so make sure you're working with an attorney that is thinking of these creative ways to settle while they're also advocating for you zealously, and making sure that they're have your best your trademark in mind, but also ways to actually solve the problem. I think it's important, and I think sometimes some attorneys lose track of that when it comes to litigation, and making sure that the costs are all up front of just how expensive it could get.
Yeah. And I think from the other side of this, Eric, when you talk about general counsel hiring large firms to enforce trademarks, I mean, we see, or at least I should say, I see a lot of bad behavior from large firms in how they go about things. Now, sometimes they're taking a scorched earth strategy, and that may be from the client's direction, and there might be a reason for that from a legal perspective. One of the things that I see is that these firms typically refuse to negotiate reasonably. They try to push a lot of cases into discovery, and I openly wonder whether or not that is a real necessity from a legal standpoint, or one that just enables the billing of some hours. So I think if you have counsel that's constantly pushing litigation, now that might get results. That's fair, and if that's what you're looking for, that's great. If it's not producing the right results, or there might be a way to produce those results in a lot less expensive and adversarial way, we do see that on our end as well. And I think there'd be a lot of our clients that would be able to say, hey, we actually get things resolved and we don't end up litigating the majority of the time. And look, there's always a time and place for it, but we do see a lot of large firms. I mean, I literally had an attorney tell me once, we do not settle cases like for this client. Like we will not sign a settlement agreement with you, despite like every concession in the book I was willing to make for this client was willing to make that really should have settled the case in any other circumstance. They basically are like, look, you either withdraw on this application or we're not going to allow it. The register is not going to be an in-between. And look, that might have been from the client, but the fact they were just like, we don't sign settlement agreements. Like, and it wasn't just my case. They said in general, we just won't sign them. And so
I had
Yeah.
a patent attorney, Josh, tell me, and this was on a career panel. She said, if we're in settlement negotiations, then I've lost. Then that means that she's a patent litigator. I was like,
Yeah.
you said the thing out loud. You're you're
Yeah.
not supposed to say that out loud. That's but no, that's exactly there's sometimes you get in this kind of tunnel vision almost where it's just like, yep, this is what we're doing. And I think that that's not great for the client most of the time.
No, and it's not, obviously we're running a law firm too. And I'll always tell a client what our financial incentive is. Cause I'll sometimes say, look, it's against my financial incentives to tell you to do this. Cause if a client's, skeptical that we should make an offer, I'm like, I know where this is going. If you don't settle this right now, why don't, is this concession really something you should think about? Because if you make it, I'm going to save you a bunch of money. If you don't make it, then, I have 4 kids and, it's not going to hurt, but it is going to cost some money. And so I think that's just something you want to really be attuned to with a lawyer that's helping you on any kind of enforcement matter is, do they have their own financial interests at heart or yours? And having open discussions about that and the cost of things is truly important. So, just to conclude, and then we can take any final questions. And I know I have to get to the CLE stuff. Let me see how we're doing on time. We got about 5 minutes. So trademark, completely valuable assets. Keep in mind, non-tangible property, meaning that it is an asset on the book once it's registered. If a business has made a decision to register a trademark or use one, they really should be willing to invest some time and money in the trademark strategy, whether everything from the clearance process to registration to monitoring and enforcement. That will keep the trademark as valuable and as safe as possible. It will also hopefully avoid litigation, which is by and far the most expensive thing you do around trademarks. That small investment can save just tons of time on each individual trademark. So if you have a bunch of them, you're going to save a ton of money. Any questions that we didn't get to today, Eric and I are always more than willing to entertain them, talk to you about them, get on the phone, email, whatever's easier. Our email addresses are on the screen. Eric's on LinkedIn. I'm on Twitter and LinkedIn. And I also have a podcast about the business side of practicing law. Like I said, I've been running this law firm for 16 years. There's the whole business side of it besides just being a lawyer that's really fun and interesting. So we got a show. I didn't have a great name. You think a trademark lawyer would come up with a good name. I couldn't. So I called it the Josh Gerben Show. You can find it on Apple, iTunes, Spotify, even on YouTube, or you can just go to my website, personal website, if you will, which is joshgerben.com, and find the podcast and all the videos there. So if you're running a law firm, you might find that to be a fun show. And I'm always looking for guests. So if you're interested in coming on and talking to me about your business, your law firm, hit me up as well. We're trying to book out guests for June and July at this point. And I think that is about it.